The law is complex, but it doesn't have to be a mystery. We are talking legal literacy, not advice. So don't worry, you're not getting an invoice. I'm Simon Jenga, and welcome to Simon Says. Today we are talking about the PPPR Act application process. So, as a refresher, the PPPR Act is the Protection of Personal and Property Rights Act 1988, governs a number of things including the drafting and execution of enduring powers of attorney and applications through the court for appointment as property manager, administrator of property or welfare guardian if you do not have enduring powers of attorney in place and have already lost capacity. So we're going to look at what the process actually looks like from instructing your lawyer all the way through to the issuing of orders and beyond. Really trying to debunk some of the myths around what is required, what isn't required, and also reduce some of the fear, anxiety over engaging in this process with the court and with lawyers. So let's rip into it. The first and most important step that you can make is instructing a lawyer that you trust. So whether that is LOA law, where we do these kinds of applications, or your trusted legal advisor you already have, or someone else in the marketplace, make sure that when you contact them, that you feel comfortable with the person that you're talking to, that you feel like they understand the position that you are in, whether it's a parent, whether it's you yourself or your spouse, whether it's a sibling or whether it's a child. Those are going to be your primary areas where we're dealing with people. And it's really important that you feel like you can be open, honest, upfront, and fully collaborative with your trusted legal advisor, because that is often going to be the difference between a straightforward application process with the court or a difficult application process where we're extracting information out of you. There are few things harder than working with clients where I'm extracting information out of them. It makes my life more difficult because I'm having to question the information that I'm given and make sure that the advice that I give is taking into account unknown factors. I need to make sure I'm very inquisitive to extract out that correct information so that the advice that I give is going to get us to where we need to go. Now, that is normal, and don't be afraid of that, because that is part of the job of a lawyer, is to know what questions to ask and to ask them in a way that elicits that information from you in a painless manner, right? It's like a dentist having skills with a drill and painkillers so that you don't get hurt when you're at the dentist. My job and the job of any competent lawyer is to make sure that when you are sitting across from me, that you are not in pain giving the information to be able to do this process as easily and efficiently as possible. So that is the first step. Get someone on your team that you trust so that when you're going through the process, you can be open and honest with them about how you're feeling and what is going on, just in case, and most importantly in circumstances where there are issues that arise in respect of the application. So once you have someone appointed, the next step is going to be for that person to gather all of the relevant evidence and information that is going to be necessary for the application to the court. So that's going to include a background history of the subject person. What has led to this point? Have they had a sudden event? Has it been degenerative? Have they never gained capacity? So whether it's a child with an intellectual disability or an adult that has developed an intellectual disability. All these factors are going to play into the nature of the application that we're putting forward to the court. And that includes financial information of the subject person. What assets do they own jointly with you if you're their spouse or a family member? What assets do they own outright in their sole name? What assets do they hold in trust? Are they a trustee of a trust? Are they a director of a company? What assets do they hold in various corporate entities? Are they involved in any partnerships? Knowing all of this background is going to allow us to not only deal with the application at hand, but also to manage all of the surrounding issues that come with someone losing capacity. So as an example, trust property is not going to be dealt with under a PPPR application because it's not personal property of the person, it's trust property, so it's dealt with separately. What that means is that even though the trusteeship of the subject person is not relevant to the application at hand, it is relevant because we need to make sure that that trust continues to operate. So we might need to change up the structure of the trust as a separate issue. So gathering all of the information allows us to make better decisions about the broader estate administration and ongoing legal structuring of the subject person. And it can give you confidence that we're looking at the whole picture. Once we've got all of that information, financial, personal, medical, then we can start to formulate the documentation to be able to go through the process with you to prepare the documents for the court application. That is going to include making sure that we've got the medical notes and the medical's certification of a lack of capacity. So that's going to be attached with the documentation and is going to be vital to the basis of the person having lost capacity. It's not me as the lawyer saying they've lost capacity. It's not you as the family member saying that they've lost capacity. It is the medical practitioner saying that they have lost the ability to make decisions for themselves and understand the implications of any decisions that they could make. And that's what gives the basis for the court to make an order appointing someone in as property manager, administrator of property, or welfare guardian. So that whole process is really important because we want to make sure that we put as much information before the court in the first instance so that we don't have to do supplementary affidavits, so that we don't have to do further disclosure to the court as questions arise. The documentation that you're going to expect to be seeing with an application is going to be the application itself, which is a relatively pro forma document that outlines a very, let's call it legalese description of the applications that are taking place. And your lawyer will work with you to make sure that the correct applications are being applied for in that instance. The real meat and potatoes of your application is the affidavit of the applicant. Now you as the family member or the person that is wanting to be appointed as property manager, administrative property, or welfare guardian, you are the applicant. So it's you that is swearing the affidavit, confirming the medical evidence, confirming your experience with the subject person, your perception of their capacity, and then also swearing to the formalities of being appointed into the roles and that you will execute your duties in those roles honestly and faithfully for the court. So that's really important. And just as an aside around affidavits, because sometimes this comes up and I find it interesting anyway, is information is introduced into the court through affidavit evidence. It's introduced by people. So your affidavit is introducing the medical evidence as an exhibit to your affidavit. That's how it is getting in front of the judge. The other documentation that we're going to have with the application generally is a notice to dispense with service on the subject person and a notice to dispense with requiring the subject person to attend the court for any hearings in relation to the application. The reasons for those two applications are that generally we're dealing with someone that has lost capacity and there's no use in requiring that person to show up in court or requiring service on that person because they have lost capacity and can't really engage in the litigation anyway. So the purpose of those applications is to allow the proceedings to proceed without involving the subject person in the formalities of what's being lodged with the court. The basis for the court allowing those applications is that once we submit or lodge the application with the court will immediately appoint a lawyer for subject person. Now that lawyer is not from my law firm if I'm doing the application for the applicant. It's an independent lawyer appointed by the court to act in the interests of the subject person. So their role is to advocate for the subject person to make sure that the court has confidence in what the applicant has put before the court. Effectively, it's a check and balance to make sure that there is no naughtiness going on with an application and that the applicant has presented all of the relevant information before the court so that a decision can be made. So that lawyer for subject person, their role primarily is to review the information that has been put before the court, question or request further information if they don't feel that it's sufficient, and then also critically to meet with the subject person to verify that on the face of it or substantively that the capacity assessment is correct. So they are meeting with the person to make sure that everything is lining up, everything is making sense, that the medical information aligns with how the subject person presents. And then that lawyer will provide a report back to the court to allow the court to then decide, is a hearing required? Is more information required? Can orders be made on the papers? Orders on the papers is where the court doesn't require a hearing with lawyers showing up and the applicant and other parties as witnesses, that is not required. That on the basis of the written documents put before the court, that the judge feels that a decision can be made. Now, generally, across the board, I find that these applications proceed on the papers. They proceed on the basis of what is presented to the court. The critical element of allowing that to happen is agreement amongst the family as to who is going to be appointed into the roles, and presenting the court with correct information and sufficient information to be able to make a decision and have confidence in the decision. If the judge feels like they've been misled, or in fact they tangibly have been misled, then a hearing is more likely. If siblings or family members are disputing who should be appointed into the roles, then a hearing is more likely. The last document that we would provide with an application that is going to hopefully sail through the court process is notices of consent. Notices of consent are signed by interested parties to the application, not being the applicant themselves. So an example would be, mum has lost capacity, I have 3 siblings, I'm going to be appointed as property manager and welfare guardian, and my 3 siblings all consent to me being appointed into those roles. They sign the notices of consent, which are filed with my application, and now the court knows that all the other people that would have equal standing before the court to be appointed objectively, that all of those people have agreed to me being appointed. The court doesn't need to hear from those people further necessarily, because it's already got the information allowing it to proceed with the decision. So notice of consent are a really great tool to be able to ensure that we can inform the court of who has consented to the application and who hasn't. So that's going to help with making an application be able to be full for the court, allowing for orders to be made. Now let's assume that a hearing isn't required, because that's the majority of the work that I focus on. If a hearing isn't required, then on the papers, the court will now issue the orders in favour of the applicant. The orders will outline what powers are bestowed on the person that's been appointed and the time that they have been appointed for. The standard timing for the appointment under the PPPR is 3 years. There are provisions for extension of 5 years in certain circumstances, but generally the appointments last for 3 years. And for a property manager, there's annual reporting, but for administrator of property and welfare guardian, there isn't annual reporting. So after the 3 years is coming up, then the renewal process begins. And that is a relatively straightforward reassessment of the subject person's capacity and whether the applicant who has been appointed into the roles has discharged their duties so that it makes sense to reappoint them. If someone's been doing the wrong things, hasn't been reporting to the court on time, and is effectively failing in their role, then the court isn't going to be as likely to reappoint them. If someone is looking out for the subject person, is dutifully looking after their property, etc., it's more likely that they're going to swan through the renewal process, because it won't be rubber stamping, but it will be obvious that they are still the right fit to be looking after the subject person, whether it's their property or their personal care. So that's the process, A to Z, starting out with getting a lawyer involved, all the way through to getting orders issued, and then the renewal process down the track. You can continue to involve your lawyer in the renewal process, or you can try and do that yourself. I've had success with clients both ways, but often involving us in the renewal process can make it short, sharp, and ensure that the documentation and information presented to the court is full, frank, and correct. At that time, more medical information is required to confirm the current status of the subject person, so that alone can create some confusion around exactly what's required. So today, Simon says, if you are starting out or in the middle of a process with the PPPR Act application, hopefully you've got a good summary, and make sure that you check in with your trusted legal advisor around the process that you're going through so you know where you are up to and therefore can anticipate what's coming next. And remember, at LOA Law, we are good lawyers for good people.